Don't even get me started. Miss McLemore, are you needed back downstairs in 20 minutes? Okay. Um, I'm, um, I don't know if everyone got my email yesterday, but suit jackets are optional today because I'm sorry for the heat in here. You never know what you're gonna get. Okay, we can go on the record. We can start with appearances from counsel.
Good afternoon, Your Honor. My name is Colleen Collins. I'm the counsel representing the applicant.
Good afternoon.
Good afternoon, Your Honor. Sandra McLemore on behalf of the Power Plant Research Program.
Good afternoon.
Good afternoon, Your Honor. Lloyd Spivak for the staff of the Maryland Public Service Commission.
Good afternoon. Mr. Spivak, are you needed back downstairs in 20 minutes?
I would like to be able to go down there, but we have Mr. Hall is actually the staff attorney on that case, so he's
Okay.
covering it. I'm sure he'll do an admirable job.
Okay.
Can I ask a question, Your Honor?
Go ahead.
There's no reason for counsel necessarily to be downstairs, is there? There's no other counsel down there. It's a public conference, so I assume not.
I just noticed that you were down there, so
Yeah.
that's why I asked the question.
Always working, yes, Your Honor.
Does everyone have their mics on? You have to kind of put the mic right in front of you. It's very directional. Thank you.
Ah, okay.
That should work better.
Yes.
They'll continue to come in and tell us if we mess up. So, all right. Any preliminary motions?
Your Honor, I just wanted to request clarification on how you would like to enter the exhibits in today.
I think we'll go ahead and just you can go ahead and mark and enter your exhibits at the beginning of each case.
Okay.
Okay.
Yeah.
That's fine.
I would also note, Your Honor, that the parties have agreed to stipulate to the various witnesses' testimony. So I think, other than marking and admitting them, it's really if you have questions for the witness. I guess there's no cross-examination from the parties.
I have all the questions. So buckle up. Go ahead.
Yes, Your Honor. Oh, and Your Honor, just as another preliminary matter, the two witnesses for the applicant are Mr. Andrew Funk and Mr. Charles Walker, but we also have available for questioning Mr. Sean Brandt, who helped put together the visual analysis and the viewshed analysis for this case within the applicant's supervision. So I just wanted to let you know that he is available for questions as well.
Thank you.
And, Your Honor, I just wanted to confirm that applicant's Exhibit 1 has been marked and entered in the record, which is the certificate of publication for the pre-hearing conference.
It has.
Excellent. And I will read through the rest of the exhibits to be entered, or marked and entered.
Thank you.
Applicant's Exhibit 2, applicant's petition filed on July 22nd, 2025, consisting of 11 pages under mail log number 320591. Applicant's Exhibit 3, applicant's environmental review document, filed on July 22nd, 2025, consisting of 59 pages under mail log number 320591. Applicant's Exhibit 4, the environmental review document appendices, which was filed on July 22nd, 2025, consisting of 657 pages under mail log number 320591. Applicant's Exhibit 5, applicant's response to notice of application deficiencies, which was filed on September 15th, 2025, consisting of 43 pages under mail log number 322417. Applicant's Exhibit 6, applicant's response to PPRP's data request number 1, filed on September 26, 2025, consisting of 61 pages under mail log number 322759. Applicant's Exhibit 7, applicant's additional response to the notice of application deficiency, which was filed on October 2nd, 2025, consisting of 5 pages under mail log number 322936. Applicant's Exhibit 8, the certificate of publication for the first public comment hearing, which was filed on January 26, 2026, consisting of 14 pages under mail log number 326554. Applicant's Exhibit 9, the Statement of Public Engagement and Participation, filed on April 27th, 2026, consisting of 8 pages under mail log number 329452. Applicant's Exhibit 10, which was an Appendix B, a confidential filing submitted with the Statement of Public
Is
Engagement.
that D or E? Excuse me.
Sorry, it's Exhibit B.
B.
B is in boy.
Okay.
That was filed confidentially with the Statement of Public Engagement and Participation, filed on April 27th, 2026, consisting of 3 pages under mail log number 329452. Applicant's Exhibit 11, the updated conceptual plan, which was filed May 29th, 2026, consisting of 7 pages under mail log number 330642. Applicant's Exhibit 12, the certificate of publication for the second public comment hearing, which was filed on June 8th, 2026, consisting of 18 pages under mail log number 330936. Applicant's Exhibit 13, the sign affidavit for the second public comment hearing, which was filed on June 8th, 2026, consisting of 10 pages under mail log number 330940. Applicant's Exhibit 14, the certificate of publication for the third public comment hearing, filed on July 13th, 2026, consisting of 17 pages under mail log number 332074. Applicant's Exhibit 15, the sign affidavit for the third public comment hearing, which was filed on July 17th, 2016, consisting of 6 pages under mail log number 332247. Applicant's Exhibit 16, the settlement status update, which was filed on August 12th, 2026, consisting of 1 page under mail log number 333167. Applicant's Exhibit 17, the direct testimony of Mr. Andrew Funk, which was filed on January 20th, 2026, consisting of 7 pages under mail log number 326387. Applicant's Exhibit 18, the direct testimony of Mr. Charles Walker, which was filed on January 20th, 2026, consisting of 18 pages under mail log number 326387. And Applicant's Exhibit 19, the supplemental direct testimony of Mr. Charles Walker, which was filed on May 1st, 2026, consisting of 11 pages under mail log number 329651. And with that, Your Honor, I would ask that Applicant's Exhibits 2 through 19 be marked and entered into the record.
Applicant Exhibits 2 through 19 are marked. Any objection?
No objections, Your Honor.
No objection, Your Honor.
2 through 19 are admitted. Counsel, does Public Utilities Article Section 7 to 18 apply to this case?
7 to 18, which would be the Renewable Energy
Yes.
Uncertainty Act. Yes, Your Honor, it does.
Okay. In everything that you just entered, is there a viewshed analysis?
Your Honor, the viewshed analysis was not filed in the docket in that entering, but it was a response to PPRP's data request number 3. So I do think that it will be entered into the record under the PAR exhibit from PPRP.
Okay. 7 to 18. F2 little 6, 1 and 2 require that a viewshed analysis be filed with the application. Is there a reason why it wasn't filed with this application?
Your Honor, I can pull up 7 to 18, so I have it in front of me, but it's my understanding that RECA requires a viewshed analysis be filed if the property meets one of the threshold requirements, which includes it being in a PFA or a PPA, priority preservation area, the historical area. I don't have the exact list in front of me.
I think, does the applicant recognize that the Monocacy River is a scenic river and that the application is in the upper Monocacy River watershed?
Yes, Your Honor, that's yes.
And that it either abuts or is very close to the historic Hessong Bridge?
Yes, Your Honor.
Okay. So would you agree that a viewshed analysis is required pursuant to 7 to 18?
Yes, Your Honor.
Okay. All right, PPRP, do you want to go through your exhibits?
Yes, Your Honor. PPRP Exhibit 1 is the direct testimony of Zachary Barthel, filed on September 5th, 2025, under mail log number 322132. PPRP Exhibit 2 is a secretarial letter dated September 5th, 2025, and also filed September 5th, 2025, also under mail log number 322132. PPRP Exhibit 3 is the recommended license conditions, filed September 5, 2025, under the mail log number 322132. PPRP Exhibit 4 is the PPRP's project assessment report, filed September 5, 2025, under mail log number 322132. PPRP Exhibit 5 is Par Appendix A, which is the applicant's responses to selected PPRP data request, filed September 5, 2025, under mail log number 322132. PPRP Exhibit 6 is Par Appendix B, which is the reference sections of PPRP's website, also filed September 5th, 2025, under mail log number 322132. PPRP Exhibit 7 is the direct testimony of Jessica Okowski, also filed September 5, 2025, under mail log number 322132. And PPRP Exhibit 8 is PPRP's response to bench data request number 1, dated August 14, 2026, and filed August 16, 2026, under mail log number 33304. And with that, Your Honor, I would request that they be marked and entered into the record.
PPRP Exhibits 1 through 8 are marked. Any objection?
No objection, Your Honor.
Thank you, Your Honor.
PPRP Exhibits 1 through 8 are admitted. And for staff?
Okay. Thank you, Your Honor. Staff has two exhibits, the first being the direct testimony and exhibit of Mikhail Spiegelman on behalf of the staff, filed May 29th, 2026. And the second exhibit, Staff Exhibit 2, would be staff's response to the bench data request filed 2 days ago. So filed on August 17th.
Staff Exhibits 1 and 2 are marked. Any objection?
No objection, Your Honor.
No objection, Your Honor.
Okay. I have questions for, I believe, all the witnesses who have submitted pre-filed testimony. So you can go ahead and call your first witness in whatever order you'd like.
Okay, Your Honor, I would like to call Mr. Andrew Funk to the witness stand.
Stand and raise your right hand, please. Do you swear or affirm under the penalty of perjury that the testimony you're about to give will be the truth? Okay, you can have a seat. State your name and your occupation, please.
My name is Andrew Funk. Would you like me to spell that?
Yes, please.
ANDREWFUNK. I'm a project developer with New Leaf Energy.
Okay. And state your business address, please.
That's 55 Technology Drive, Suite 102, Lowell, Massachusetts, 01851.
Okay, thank you. Did you have any questions for your witness?
No, Your Honor.
And any other party have any questions for this witness?
No, Your Honor.
No, Your Honor.
Okay. The August 12th letter filed by your counsel indicates that the applicant has reviewed and will not contest the proposed license conditions of PPRP and staff. Is that true?
That's correct.
You sponsored the ERD sections 1, 2, 3, 4, 5, 9, and co-sponsored section 8. Is that correct?
That is correct.
What is the address of the access roadway? What will be the address of the access roadway of the project?
I believe we are still in the process of establishing a 911 address for the property. It would be separate from the parcel address.
A updated site plan was filed on May 29th, I believe, the same day as PPRP and staff's testimony was due. Has the site plan been updated since that day?
What date was that, Your Honor?
It was filed on May 29th.
To my knowledge, Your Honor, there have been no updates since that date.
Okay, construction was anticipated to, as of the time of the application, construction was anticipated to begin in the third quarter of 2026 with completion and operational startup in the first quarter of 2027. Is that still the schedule?
No, Your Honor. Construction would not be until reference. Would not begin until the beginning of at least the second quarter of 2027.
I believe for this project, the proposal is to interconnect with a trenched underground from the equipment pads along the access road to the proposed utility poles on Hessong Bridge Road.
That's correct.
Okay, I see some huge site plans up here, which I love. Can I go ahead and make use of those?
Yes, Your Honor. They're for your discretion.
Okay, I'm looking at a site plan, and it's denoted in the bottom right-hand corner, C-SP-2.0, and there's a date on there, January 28th, 2026, and it says, drawn TR, check DE, Frederick County submission. Is that the latest plan?
That is my understanding. That might be better clarified by Witness Walker, who printed the plans.
So changes from site plan to site plan, questions about that I should direct to Witness Walker.
Yes, Your Honor.
Are you able to point out on this plan where the proposed trenching is, where the interconnection is, and where the existing utility pole is?
I could do my best, Your Honor.
Or should that question go to
Yes.
Witness Walker? Okay.
Yes, Your Honor.
Is the project consistent with Frederick County's comprehensive plan?
The project is consistent with the Livable Frederick Master Plan, as stated by the county in an attachment included in our data request number 3.
Is the project consistent with Frederick County's zoning ordinance?
The project is mostly consistent with the ordinance. However, in Frederick County, solar is only permitted as an accessory use in all zoning districts. The definition of accessory use is that the solar itself has to be on the same lot as the principal use or an existing building. This project is located across the stream. The parcel spans the stream, but it's located on the other side of the stream as the building. So it could be interpreted that we are not in compliance with that accessory use portion of the code. The county's letter response to, after we submitted the ERD to them early on, stated their accessory use code, however, didn't explicitly say that we were not in compliance. However, Your Honor, I think there's a lot of interpretation under that code, so it's not entirely clear if we are not within compliance.
So is the applicant going to make an application for an accessory use designation?
No, we do not intend to make an application for accessory use. We're currently in the permitting process with the county, and that has not been stated as a requirement.
Are there any other county requirements that you're asking be preempted?
No, Your Honor.
Several places in testimony and in the ERD, it indicates, or maybe it's not there. Several places in PPRP witness Barthel's testimony, there are references to recommendations from Frederick County, and that the applicant has said that they will comply with those recommendations. Where can I find those recommendations in the record?
That should be PPRP data request number 3. And then within that,
Can you see if you can bring the mic closer to your?
Sure.
Is it on?
yes.
Okay.
Is that better?
Yes.
Thank you.
Three dash what?
My apologies. It would be data request number 1, attachment 1-27.
So that's not in the record. That's not attached to PPRP's testimony or to the applicant's filings.
Can I just have a moment to confirm? Because I did, applicant's exhibit 6 is the applicant's response to PPRP's data request number 1, but I can confirm that that was uploaded with in my files that I have. Mr. Funk, can you say what attachment that was again?
1-27.
Yes. That was filed, Your Honor, I believe. I'm just going to check the docket.
I got it. Okay, so what, in the applicant's filings, when it indicates that it received recommendations from Frederick County, those are all contained within the May 19th, 2025 letter from Frederick County?
Aside from any that we, maybe not formal recommendations that would be in back and forth email coordination throughout
For
the
example?
well, specifically in the attachment I referenced, they requested stated their 25-foot vegetative screening requirement. However, further conversation, and as they developed their ordinance, they requested that to be increased to 35 feet, so we obliged. Other than that, if there are specific design components that the county requested through our local permitting process, that would be addressed by Witness Walker.
Do you have communications with the county by email or letter post May 19th, 2025 that you can make available?
Yes, Your Honor. Yep.
So the 5 areas where Frederick County made suggestions for changes to the site plan include the landscape buffering, grading, setbacks, and obtaining access permits. Can you describe the changes that were made in response to the county's requests?
As previously stated, we agreed to not only abide by that 25-foot request, but go even further for 35 feet. For those other items, being that they're more design related, I would defer to Witness Walker. I believe we're in the process of pursuing the access permit, but that typically comes later on in the process.
Okay. Did you provide notice to local fire stations, including a map of the proposed generating station and the proposed location of any solar collector or isolator switch?
No, that's typically our standard process. I don't have that information in front of me right now to confirm that, so I don't want to misspeak. So I'd request a follow-up with a data request on that, unless Witness Walker can confirm.
What is there in the record that, aside from the visual impact analysis attached to PPRP's testimony, that 2-page visual impact analysis provided pursuant to PPRP data request 3-4, what else is in the record to denote the visibility to neighbors and roadways in years 0 through 5, or 0 through full maturity of the buffer?
Aside from the viewshed analysis, I think some of that information could be deduced from the glare analysis, but other than that is the only viewshed analysis on record.
Are you the witness for the glare analysis?
I would defer to Mr. Brandt, the project engineer.
So the ERD at page 10 suggests that a berm might be used, but in the attachment B to Witness Walker's supplemental direct testimony at 16, said should be 16. 16 on your current site plan, it says the use of a berm is not required for screening purposes. Is there a berm going to be used?
I do not believe we currently have a proposed berm. And that
Okay,
would
so I do not believe we currently have proposed is kind of a qualified statement.
Yeah, we're not proposing a berm for this project.
Okay, thank you. What is the elevation of this property as compared to the surrounding properties?
It's on kind of a crest of a hill, so up to the northern border of the property crests the hill, and so it's up above, and then it slopes downward to the north.
Sorry.
Or sorry, I'm upside down.
I think this designates north this way.
Yeah, my apologies. The crest of the hill is the south, and then it slopes down to the north.
Okay, and the surrounding properties on the south side are approximately the same height as the project site on that side?
Yes.
Okay, and then the roadway is below that elevation, is that correct? Both of the roadways?
Which roadway are you referring to?
Hesson Bridge Road and whatever that other crossroad is.
Yeah, Hessong Bridge Road will follow the contour, so that it'll actually go down in elevation as well.
But is Hessong Bridge Road at the same height as the project site along the eastern edge of the project, or is it, 3 to 4 feet or 6 feet below the project at that point?
I'd say it's slightly below the project.
In public comment, one of the commenters suggested that this is 46.8 acres of a 142-acre parcel, and asked why the project was developed on this side and not on the other side, which may be further from more widely used roads. Did you consider putting it on the other side of the property?
We did, and through conversation with the landowner, most of the farm buildings, as I said earlier, exist over there. He plans to continue to farm that area, and so to have equipment on that side of the stream made more sense as we were discussing and designing early on.
Okay. Can you describe the type of single-access tracking that is proposed to be used? I just want it in plain English, so I have it on the transcript, or not transcript since we don't have a court reporter, but on the hearing transcript.
Okay.
Kind of.
Okay. Single axis tracking is just designed to follow the sun throughout the course of the day to optimize efficiency of the system.
So which way will it track?
It will track from east to west.
Okay. What is the maximum height that the panels will be at full tilt?
At full tilt, I don't have that number ahead of me. I would defer to Mr. Walker.
At the end of the day, the single access tracking will angle the panels towards the home that's across the street on the eastern side of the property. Is that correct?
Well, I believe they'd be angled to the west at the end of the day.
I'm sorry, I meant west. To this home on the other side of Hessong Bridge Road.
That's correct.
All glare questions go to the other witness?
Yes.
Okay. I understand that there's going to be, the plan calls for minor grading in areas to allow for site access and improvements for stormwater management. Can you tell me where that's going to happen and what that grading entails?
The grading specifically for the access road will occur at the access road on the coming off of Hessong Bridge Road, and that's the extent of essentially the grading there.
And improvements for stormwater management?
I believe we're using rooftop disconnect for this project, so I don't believe that there are structural BMPs for stormwater. But
The application at page 5 says there will also be minor grading in areas to allow for site access and improvements for stormwater management, and cites the ERD at 8A3, which says, you might be able to get there before I can. I'll just ask you this. You don't know about any grading other than in the area of the access road?
No, I do not, Your Honor. We're currently in the process of working through stormwater management designs with the county. It's my understanding that we, per licensing condition, would need to file in that approved stormwater plan. So, but no large BMPs. Witness Walker may be able to speak more clearly to that, but I don't believe we are currently proposing grading for stormwater.
Are you applying for a pollinator-friendly designation?
We are not. We intend to plant pollinator-friendly seed mix, however, not applying for the designation.
Where do you intend to plant pollinator-friendly seed mix?
Within the fence line, essentially over the where the entire panel area.
What type of pollinator-friendly seed mix are you talking about?
I believe it's referred to as Fuzz and Buzz Ernt Seeds mixture. I believe is what we have currently proposed on this project.
That's not. Would you also describe that as meadow grasses, native meadow grasses?
I can't speak to that. I don't know if there's a distinct difference between the two.
I think you gave at least one of the presentations at the at one of the public hearings, or maybe two. Is that right?
Yes. Yes.
And I think you put up a slide of community benefits that said diversification of local flora and fauna through planting of pollinator-friendly vegetation, which will have direct benefits to neighboring farmland.
Mm-hmm.
Does that sound familiar?
Yes.
I have a copy.
Yep.
Okay. I have copies if any council want to see that as well. Are you familiar with Public Utilities Article 3-301D, which says the owner of a solar generating facility may not claim that the facility is pollinator friendly or that the facility provides benefits to pollinators, songbirds, or game birds unless the facility has been designated as pollinator friendly by the department in accordance with this section?
I was not aware of that, no.
The site plan indicates in the notes that the buffer should be planted as early in the construction as practicable. And I think that's pursuant to the code. Is there any reason why the buffer couldn't be planted first as one of the first items of construction?
Given where our construction laydown area is proposed, I don't see why it couldn't be planted ahead of construction. Yeah, I personally do not see why not, given my knowledge on the construction process.
Is the fence proposed to be inside or outside of the buffer?
Inside.
And what is the intended height at planting of the buffer?
I believe it's 6 feet.
Okay, so that statement was a little bit qualified. I believe it's 6 feet, and I really want a definitive answer because there's places where in the applicant's evidence where it says 4 feet, there's places where it says 5 feet, and there's places where it says 6 feet. So I need to know what to rely on. Let's look at this latest site plan and see what it says. Trees must be more than 4 feet in height at the time of planting, is what it says on your latest site plan.
apologize, Your Honor. I'm looking for, I thought this was referred to in a data request, and I'm looking for that clarification.
It is in a data request, and I'm looking for it as well to try to help out. I think it might be in PPRP data request 3-3.
Specifically for the glare analysis?
Well, the company's response to 3-3 subsection B is the proposed planting height has been revised to 6 feet. And then it goes on to say the 8-foot buffer presents conditions after 2 years of growth. Both 8 and 6-foot buffer glare analysis are attached as attachment 3-3. So I guess my original question is, at what height are the buffer plantings going to be planted?
6 feet, and I believe that what's stated on the site plan is an error and maybe carry over from previous plan.
Okay, so I can take that to the bank and put it in my proposed order, 6 foot?
Yes, you can.
Great. At what year will the buffer be opaque?
Trying to find that information in the landscape plan. The landscape plan was prepared by ARM Group, so that that might be a better question for witness Walker, as I'm having trouble locating it now.
I hope Mr. Walker is taking notes as to all the questions. So the vegetation management plan that's attached to Appendix P of the ERD that was provided by the ARM Group, those questions should go to witness Walker as well?
Yes, Your Honor.
Okay. Do you know what the water source is for this project?
I want to be careful not to misspeak here because I know we went internally went back and forth debating between a well and trucking water on site. Believe we landed on a well, but I know that that's not a definitive answer. So.
If there was a well proposed, would that be something that would be designated in the site plan for use by the same contractor?
It should be, yes. Yeah,
Okay.
in the certainly in the approved site plan that would be filed.
And if it was trucking of water, would that be something that would also be in the portion of the site plan, that portion of the site plan for landscape maintenance?
Yes, I believe it would be stated in the same.
Okay. PPRP condition, proposed condition 23, vegetation management, requires the applicant to provide a grounds management plan. That's not the same thing as the applicant provided in Appendix P, the vegetation management plan, is it?
Can you restate the question?
Do you have PPRP's conditions in front of you?
I don't believe that's in my folder, Your Honor.
Okay, so on page 7 through 8 of PPRP's proposed conditions, it's condition number 23. It's entitled Vegetation Management. It says prior to construction, the project owner shall comply with the following requirements, and then there's a few things. And then section D says the project owner shall develop, file in the docket, and implement a grounds management plan that includes something consistent with agrivoltaics activity, which you're not doing agrivoltaics in this case, correct?
We are not.
Okay. 2, a schedule that minimizes mowing and that when at all practicable avoids mowing activities during the nesting season of most ground nesting birds, May through August, yada yada. And then 3, a limit on grass mowing height at all times to not less than 10 inches. 4, a protocol for managing invasive plant species consistent with county regulations. 5, a plan for avoiding or minimizing the use of herbicides or pesticides. And 6, integrated vegetation management protocols for establishing and maintaining self-sustaining vegetated buffers without mechanical mowing. That's not something that the applicant has done yet. Is that right?
I don't believe so. I'm looking at the vegetative management plan right now, and I don't think it would address all of those. So it would, while this might be used as a basis for that licensing condition, we would have to update this to satisfy those requirements.
Okay. Noted on the site plan are sycamore, DBH sycamore trees. What is the significance of that? It's near the river.
I don't know why they're specifically called out. You said DBH?
31 DBH sycamore and 30 DBH sycamore, 33 DBH sycamore, DBH tulip poplar, DBH 32 DBH sycamore.
Let me confirm, but if they're called out specifically, those specific trees on the site plan, they would most likely be specimen trees, and therefore to be avoided, specifically their root zones.
That's not, is that addressed anywhere in testimony or in evidence?
The ERD would have would have the forest stand delineation, which would call out specimen trees.
Can you point me to that, to where that is?
Your Honor, that would be Appendix Q, the forest stand delineation.
Yes, Your Honor, I see them on the.
So, did the applicant receive any recommendations regarding avoidance?
Recommendations from who?
Well, this was the ARM group prepared this attachment Q. And it's in compliance with Forest Conservation Technical Manual guidance. There's information, but there's no conclusion or statement about how the project proposes to avoid these areas, or there's nothing, there's just information here.
Okay. But we are avoiding with the current site plan, the critical root zones for those designated specimen trees.
Okay, and so fencing is allowed within those critical root zones?
I do not know, but I don't believe so.
Okay, can you take a look at the site plan?
Sure.
That's in front of you. And I'm going to point out two areas. They're in the very center of the site plan. The first is designated 31 dBH sycamore, and the second one is designated 30 dBH sycamore. It looks like there's fencing running through those circles drawn around those trees. Can you take a look?
Yes, I see that, Your Honor. It does look like the fencing is going through those critical root zones.
Okay, while I have you looking at this, I see where the proposed landscape buffer yard, I think it says 25, I think it says 25 feet wide, but you've told me that you're doing a 35-foot wide buffer. That's right?
That's correct.
Okay, so I see where it starts at the northwest-ish corner of the limit of disturbance, and it ends at the east, pretty much straight east limit of disturbance. And it looks like if you look further east towards the edge of the property, that there are no trees there. Right here, it looks like there's no trees. And this ends right here. And then on the left side, it looks like it ends right here, and are there no trees in that direction? Existing trees?
Off map here.
Yeah.
There are trees along the entire stream.
Okay, and then in the other side? On the eastern side, where it says 100-foot setback?
There is that gap that leads to another field, farm field, but then I believe there are more trees in the area.
Okay. Thank you. Public Utilities Article Section 7-306.2N relating to community solar. The pilot program states that the developer of a community solar energy generating system shall ensure that workers are paid not less than the prevailing wage rate. Will the applicant comply with that?
Yes.
Hessong Bridge, is that a historic property?
Yes, Your Honor, I believe it is.
Okay, historic to who? How is it designated an historic property?
I'm looking for the Medusa screening. I believe it was called out on that. That was designated by, I believe, MHT. I'm looking at in the ERD Appendix F, MHT correspondence. It is identified as in their inventory number F65.
It's listed on the Maryland's inventory of historic properties. Do you know if it's listed on the National Register of Historic Places or relevant county register of historic places?
I do not know the answer to that, no.
Are there any, within 1 mile of the project, are there any other preservation areas, rural legacy areas, priority preservation areas, public parks, scenic rivers or byways, or designated heritage areas or historic structures or sites listed on the National Register of Historic Places or the relevant county register of historic places?
Our outreach regarding that is specifically to MHT for MHT clearance. So if it was not flagged in their response letter, then I don't, I'm unaware of any.
How far away is Catoctin Furnace?
I don't know.
What about the remnants of Black's Mill?
I'm not sure.
Okay. So you did not do any other searching other than reaching out to MHT for this information.
That's correct. Yep. And we also do a Medusa screening. We go to the Medusa website to do that as well as a preliminary step.
And you said that's in the ERD at Appendix F? The Medusa screening?
No, we do that as an internal. I don't believe we attach the screening here. Let me make sure it's not included in that appendix.
I don't think it is.
I don't believe so either.
Okay. What were the recommendations of the Sustainable Monocacy Commission?
I know that one of their recommendations was to look into the relief program, which is to essentially plant a riparian buffer to the unused area outside of the fence line towards the stream. I've discussed that with the landowner, and they intend to do so, provided the project were to go through. That was their, if I recall, while I'm pulling up their response, one of their main
So
comments.
making the compliance with the Frederick County Creek Relief Program as a condition of the CPCN would not be a problem?
No, I don't see an issue with that.
I think there's some conflict between some of the filings as to mowing. Have you seen PPRP's recommendations with regards to, in their vegetation management plan, with regards to mowing?
Was it to not mow less than to a length of 10 inches, I believe?
And limited to the spring and fall seasons?
Okay.
Let me ask this question this way. Hang on.
Sure.
Can you turn to Appendix P to the ERD?
Yes. I'm there.
At page 2. The vegetation management portion at the second paragraph says ground cover shall be mowed a minimum of once per year. Additional mowing may be necessary and will be noted in the annual report. It doesn't address PPRP's suggestions. Is the applicant able to comply with PPRP's suggestions?
Were those suggestions located in licensing conditions?
Yes. Condition. $23.
I thought I might get lucky and find them. I don't believe I have the licensing conditions in front of me. Thank you. Yes, I recall reviewing these with my team. We will comply with those.
So the vegetation management plan will be updated post CPCN and prior to sending the site plan to the county, and vegetation management plan to the county to comply with PPRP's recommendations.
Yes.
The ERD at page 3 talks about a tax revenue yield, but doesn't give an estimate. Do you have an estimate for that?
What page
3?
of the ERD?
Yes. It's in the third full paragraph on page 3, the last sentence. The tax revenue yield for a project of this size and type will also support critical county and state tax-funded programs that are often in desperate need of additional resources. The ERD at page 24, the first paragraph, appears to give an anticipated average annual tax benefit. Can I apply that statement to the earlier statement?
Yes. Yes, I was looking for that section.
Can you turn to page 10 of the ERD, please? At the third full paragraph, kind of midway down, it says the determination of the buffering and screening elements will be made by the county council, taking into consideration the characteristics of both the project location and the surrounding neighborhood. Is that anticipated at the time of the approval of the final site plan? Or is that something that's ongoing or has already been received?
I'm sorry, Your Honor, I'm locating that. You said page 10?
Page 10, and then the third paragraph.
Okay.
It's a little more than halfway down. This is where it says the buffering and screening area is anticipated to consist of a combination of berms, evergreen species that are at least 5 feet in height at the time of planting or fencing, which we've already decided is 6 feet, right?
Yes.
And the determination of the buffering and screening elements will be made by the county council, taking into consideration of the characteristics of both the project location and the surrounding neighborhood. That determination, the question is, that determination will be made at the time of the approval of the final site plan, or is that something that's already been done or is ongoing?
That will be at the approval of the final site plan.
At the public comment hearing, one member of the public, or more than one maybe, commented about use of the water on this property for fishing. And also transportation traffic on the bridge. Does the applicant have any response to those comments?
Our project would not prevent the continued use of that stream for fishing.
And increase traffic on the one-way bridge?
We are required to provide a traffic management plan, so I think that would be addressed there. Let me see.
Has the applicant given any consideration to having the increase in construction traffic routed south to avoid the one-way bridge or one-lane bridge?
looking to reference my traffic plan here. If that has not already been contemplated in our traffic plan, it's certainly something that we would entertain.
Okay, I think that concludes my questions for this witness. Do you have any questions based on my questions?
No, Your Honor.
Okay, thank you for your appearance this morning.
Thank you.
Okay, you can call your next witness.
Your Honor, we would call Mr. Charles Walker to the stand.
You stand and raise your right hand. Do you swear or affirm under the penalty of perjury that the testimony you're about to give will be the truth?
I do.
You can have a seat. Can you state and spell your first and last name?
Yes. Charles Walker, CharlesWalker.
And Mr. Walker, can you state your employment and business address?
Yes. I'm employed by Arm Group, LLC, and business address is 9175 Guilford Road, Suite 310, Columbia, Maryland, 21046.
Okay, counsel, do you have any questions?
No, Your Honor.
PPRP and staff?
No, Your Honor.
No questions, Your Honor.
Okay, you've been sitting in the hearing room listening to all the questions I've been asking so far, right?
Yes.
Okay. So you're ready to go.
Yes.
Okay. Is the site plan that I have in front of me the latest site plan, or have there been more site plans issued?
There have been very minor updates to address county comments, and it has been resubmitted to them since the date of this May 29th.
Okay.
set.
So, so I think if I'm right, that there was a set of site plans filed with the application, and then there was a set of site plans filed as an attachment to your second set of testimony, and then there was a third one filed on May 29th. Is that right?
Yes.
Okay. So can you go through and tell me what the changes were in each one of those?
I can give broad strokes. So the original.
Hang on a second. I don't want broad strokes because I can kind of see broad strokes for myself.
Okay.
The May 29th filing says that the applicant revised the conceptual plan to more, it's the cover letter to the filing. The applicant revised the conceptual plan to more accurately reflect the property boundaries and to update the buffer distances in response to PPRP's data request 3. Specifically, the plan now reflects a 100-foot buffer from Little Hunting Creek based on its perennial classification while maintaining the 50-foot buffer from the unnamed tributaries based on their intermittent ephemeral classifications. So that statement clarifies how the buffer distances were updated, but it doesn't explain how the plan was revised to more accurately reflect the property boundaries.
So I believe it was updated based on the boundary survey that was done. I believe the original plans that were submitted, the boundary was a GIS sourced boundary. And then with this latest update, I believe the official surveyed boundary was incorporated into the site plan and the setbacks.
Okay, so where would I expect to see changes between the two versions?
They would be very minor, essentially just line work at slightly different angles.
Okay. While we're on the site plan, the sycamores with the fences going around the avoidance area.
Yes.
where do I find authority to say that panels are not allowed in that area, but fences are allowed?
I don't think there is a conclusive statement on what is allowed and what's not. Typically in the Forest Conservation Technical Manual that's referenced in the FSD, they do talk about how you can disturb up to 30% of the critical root zone, but it doesn't explicitly state what disturbance is. It's like if a fence line just crossing over it would be disturbance, if it would be grading, if it would be panels. It doesn't explicitly say. But I believe we did place the fence line to be impacting less than 30% of the critical root zone of those trees.
Have you done site visits, or are you more a computer guy?
No, I've been to the site.
Are the roots of these old sycamore trees, are they above ground or below ground?
I don't know if I could conclusively say. I don't think I've looked at those trees specifically.
Okay. Did you develop the site plan?
Yes.
Okay. The portions of the buffer that are proposed in the site plan don't go all the way around the project because of existing trees. Is that right?
The portions of the setback or the stream
The
buffer?
buffer.
Oh,
I'm
the
sorry.
landscape buffer.
The landscape
Sorry.
buffer. Yeah.
Yes, that is correct.
Okay. To the east side of the property, the landscape buffer ends, but it looks like further east there is no existing tree line based on the site plan. Is that right?
That is correct. There's a slight gap.
Okay. Is there any agreement with the property? This is proposed to be a lease, is that correct?
Yes.
Okay, is there any agreement with the property owner with regards to maintaining the existing trees?
I believe so. I'm not involved in that process, and I haven't seen the lease, but I do believe we have a 50-foot wide strip that incorporates along the stream the existing trees to be part of the lease and not disturbed.
What about the existing trees that you can see on the site plan kind of right next to where it says RGA?
I don't believe those trees are incorporated into that 50-foot strip.
You are not the person who developed the visual impact analysis, is that
I
right?
am not. No.
Okay. I'm going to start going through my questions again, some of them that we skipped.
Mhm.
You are not aware of what the address would be for the access road?
I'm not. I don't believe it's been assigned yet.
Are you able to point out where the proposed interconnection would be on the site plan? Where the existing Potomac Edison utility pole is, and where the trenching will occur?
Yes.
Can you do it on this big one?
So the utility trenching is this MV line type that follows the access drive. These are the proposed poles where it starts to go overhead. And then this is the point-of-point connection pole.
Okay, and so you've pointed out along the, I'm trying to figure out how to say that for the record. Along the proposed access drive on the right side, from the middle of the project up around the curb and to the outside of the fence area of the access drive, at which point it would go above ground and there would be 2 poles, and then it would be connected to the point of interconnection, which is still on the same side of Hessong Bridge Road.
Yes, but there are more than 2 poles.
How many poles?
6 proposed poles and then the point of interconnection pole.
So 6 additional poles.
Yes.
Okay. And what type of trenching are we talking about for that area?
So it would be, let me get the exact dimensions. We have a detail for it. I believe it's on this plan. Yes. So on the site plan sheet C-SP-3.0, it's the last sheet.
Okay.
Detail number 5, the detail conduit trench, that would be for that medium voltage trenching.
Okay, thank you for that.
Mhm.
While we're on the site plan says that trees will be planted at 4 feet. You've just heard the testimony that the trees will be planted at 6 feet, so that would be changed before it's submitted to the county.
So that language actually is from the county. They wanted us to put that whole set of notes on there that said the tree shall be a minimum of 4 feet, so it's just a minimum.
Well, so I've always been told that if it's not in the site plan, the contractor's not going to do it. Is that fair to say?
Yes.
So if we submit the site plan like this to the county and it says 4 feet, then what's the contractor going to plant?
So there will be additional plans. There's a detailed landscape plan, the stormwater plans. So they would have all of that.
It's usually attached to this in similar format. It's just an additional page, correct? Is that what you're talking about? Or are you talking about the landscape plan that the vegetation management portion of the plan that's attached to the ERD at Appendix P?
No, so not the vegetation management plan.
Okay.
There will be a detailed landscape plan on plan sheets 24 by 36 like these, and that will be prepared and stamped by a registered landscape architect.
And that will have the exact trees and bushes that would be planted in addition to the pollinator seed mix, etc.
Yes, yeah.
Will that also have the water source and the frequency of watering?
If irrigation is required, it would likely have a water source. That actually has come up recently. Sometimes they don't consider it under their purview. Sometimes they would put that under a like a maintenance obligation or like landscape installer.
Do you have the ERD and appendices in front of you?
Yes.
Can you pull up Appendix P?
Yes.
The very last paragraph on page 2 says all proposed plantings shall be maintained by the owner's representative following installation. Who's the owner referenced there?
I believe that would be the owner of the project, the solar project.
Two paragraphs up with a paragraph that starts with vegetative screening. Are you there?
Yes.
It says, at each scheduled site inspection, on-site vegetation and vegetated buffer plantings will be inspected and reviewed for plant health. How often are those scheduled site inspections?
I could not answer that.
Okay. One paragraph up from that, it says, sorry, did you prepare this vegetation management
I did
plan?
not.
But it was prepared by Arm Group.
No, it was prepared by New Leaf.
Okay. Do you know what the max height of the panels will be at full tilt?
Yes. They will be 9.5 feet based on the latest design.
Is that usually included on the last page? That the detail on the last page of the site plan?
Yes.
There's no fence. Oh, 9.5. It says 9.5 feet on the left side. That's at full tilt.
Yes.
Okay, and that's the maximum that the project as designed would have at this point?
Yes.
Okay. The latest site plan has noted a 35-foot landscape buffer and a 100-foot perennial stream buffer, which was part of the changes from the last plan. Is that correct?
Yes.
Okay, and those will continue in the plans that are submitted to the county. Is that correct?
Yes.
In your supplemental testimony, you indicated that the limit of disturbance was reduced from 42.16 acres to 40.78 acres by moving closer to the landscaping along the southern side and avoiding the tree line and stream buffer to the north side. Are you able to point out exactly where that is?
Possibly. I'll need to pull up the site plan before that. Sorry, I'm just having trouble finding the exact one. Sorry, I can't find the plan where we said it was the original 42.16, but I have the one that says in the supplemental testimony where it's 40.78. I can point to the southern side in the tree line.
You mean generally?
Yeah, like where it pulled in. I vaguely remember where it.
All right, it's fine. Okay, so there is a house directly across the street to the west side. I'm not sure what the address is, but it's shown on the site plan. Do you know what I'm talking about?
Yes.
Might belong to a James R. and Diane B. Sweeney.
Yes.
Okay. Do you know what the elevation is of the land in front of that house, or that the house is set on?
Yes. It looks like it's approximately at elevation 414 or 416.
And what about the project elevation at the nearest panel directly across the street? It would be the panel at the top of the second row from the bottom, where it says 291 feet residence to panel.
That would be approximately elevation 408. That dimension.
So from the ground level, the house across the street is slightly looking down on the panels nearest to it.
Yes.
What is the height of the roadway in between the elevation?
Right at that point.
Yep.
It looks like approximately 411.
Okay, and the map that you're looking at, is it just a site plan, or is it does it have a little bit of a wider area?
I'm just looking at the proposed site plan sheet.
Okay, I think, do you know what the elevation, to the southwest, across Hesson Bridge Road and the east-west road there is another residence. Hang on a second.
Thank you, Your Honor.
Do you recognize this aerial photo from Google Earth?
Yes.
Okay. And the property that we're talking about is right here. Is that correct?
That's correct.
Okay. This house right here, which is across Hesson Bridge Road and south of the east-west road right there. Do you know what the height is, the elevation is of that property?
I do not.
Do you know what the water source is for the buffer?
I believe if a water source was needed, it was planned to be a well for the trip
Do you
irrigation.
know where the well would be located?
I do not.
Do you recall any other questions that I asked that I was directed for you to answer?
don't believe so. I could potentially provide a little bit more detail on the historic property, historic bridge.
Oh, that'd be great.
So Arm Group did that coordination with MHT, and to the best of my knowledge, they checked the box on the MHT form that just said it was a MHT identified historic resource, not local or national. Those are check boxes that are on there, but they weren't checked. So to my understanding, it would just be a MHT resource. And it also noted in that correspondence that the original bridge that was there had been destroyed, and they have pictures of it being worked on, constructed.
Okay. Okay, thank you very much. I don't have any further questions. Do you have any questions based on my questions?
No, Your Honor.
Okay. You can have a seat. Can you leave that picture?
Yes.
Yeah. Thank you. Last witness for the applicant?
Your Honor, before we call the last witness, do you mind if we take a 5-minute break?
No, that sounds great. I'm going to go get my trustee office thermometer and see what the temperature is in here. Thank you. 5 minutes? 10 minutes? Okay.
It's warm. It's not. It's getting warmer. It's not horrible yet, but we haven't. The opportunity to take off the shoes.
Yeah, please have that.
Which house they
I think
were?
she was talking about that one, wasn't she? Because she said it was south of the road. So I thought they were talking about that one, but I'm not for sure.
Well, I saw Drew point up here too.
Oh,
That's. I'm sure if she asked me about it, I can. This one I'm not concerned about because they have their own solar. Right. I think, but I
That's
think so.
solar?
This is
That's solar right there?
this is Black's Mill. I know a
Yeah.
couple of the places she's talking about that are
Yeah.
the public brought up. Phantom hits. There's
With Phantom Hits, what's that?
6. Somebody said in the public hearing that there are 6 historical. I'm gonna say 84. Okay, that's my FanDuel bet.
I wasn't able to, you didn't.
There are
dance.
3.
With my stomach.
Is the break long enough?
Yes, thank
Okay.
you, Your Honor.
Okay, applicant rests.
Would you like us to call Mr. Brandt?
Oh,
to,
that's right. Sure.
We would now call Mr. Sean Brandt.
Raise your hand and do you swear or affirm that the testimony you're about to give will be the truth?
I do.
Okay, can you sit down, please, and state your name and your business address and your position?
Sean Brandt. Business address is 55 Technology Drive, Suite 102, Lowell, Massachusetts 01851. And my position is Senior Civil Project Engineer.
Okay, any questions?
No, Your Honor.
What specifically were your duties with regards to this project?
I I had a lot to do with this project, but I believe I'm here to speak specifically about the glare study and the view shed analysis.
Okay, and by the view shed analysis, the applicant didn't submit anything, but they responded to PPRP data request 3-4 and submitted a 2-page analysis. Is that what you're referring to?
Yes.
Okay. Are you an employee of ARM or New Leaf?
Newly, sorry.
Okay. The analysis that PPRP attached to its testimony says this viewshed analysis was created for informational and planning purposes only. It is not a substitute for a field verified on the ground survey and should not be used for legal, engineering, or surveying purposes. The results are a computer generated model of a proposed surface and should be interpreted as an approximation of potential visibility, not as a guarantee of actual views.
That's correct.
If it shouldn't be used for legal purposes, why should I rely on it?
It is the best representation that we can provide without the aforementioned field studies.
Did New Leaf perform the aforementioned field studies?
No, those were not. I mean, we did we had a survey performed for like standard topo and boundary, but not anything specific to like on the site visual analysis. To add a little more context, if I may, the data that goes into the viewshed analysis that we provided is based on publicly available GIS data, including topography, ground contours, known tree heights, things of that nature. So it's not to say that it's inaccurate. It just that statement is there as a qualifier that we weren't doing a specific on-site field study for it.
What were the assumptions?
The assumptions for like vegetative buffer height, things like that.
Yes.
The vegetative buffer height is 10 feet, which is meant to represent the majority of the lifetime of the project following somewhere between 2 to 5 years. The panel height is I believe it's modeled at 8 feet to represent the kind of central point or close to the central point of the panels as they're rotating because they're not fixed in place. As mentioned before, trying to think what other assumptions there would be needed here.
Parties, I'm not going to accept PPRP data request 3 and the attachments as a part of the record. I don't think there's sufficient, there's no detail given as a part of the response. It just says a viewshed analysis has been completed. There's no detail as to the assumptions. The witnesses just testified that the buffer is 10 feet at 2 to 5 years, which I think we all know is kind of a really broad general assumption. The panel is 8 foot, and the previous witness testified that the max height of the panel at full tilt is 8.5 feet. It purports to give the view shed from 8 receptors, but we don't know what those receptors are. And there's a specific amount of glare from a yellow receptor, but it doesn't really show which yellow receptor that glare is from. Furthermore, there's testimony from the applicant both of zero glare and also of glare in the amount of to the receptor directly across the street, which I guess is labeled 3. It's a home directly across Hessong Bridge Road that has several hours of green and some hours of yellow. There's some testimony that the glare analysis was done twice, but there's no real evidence about what was changed between them and which one's right. And I just don't feel like this is something that I'm going to accept into the record at this time. So the applicant has not met its burden on glare.
Understood, Your Honor.
May I speak?
Just give me a second. Counsel, I realize that this is a case where 7-18 applies, and this was filed very quickly after that, but it has been some time. There's also the requirement of 7-07 that the commission consider aesthetics. I also don't find that the applicant has met its burden with regards to the view shed analysis of what the homes in the vicinity expect to see at years 0 to 5, etc. So we're going to talk later about how to rectify that situation.
Yes, Your Honor.
You can start thinking about that. All right, I don't have any further questions for this witness. Thank you.
Thank you, Your Honor.
PPRP? Oh, applicant rests?
Yes, Your Honor.
PPRP?
Yes, Your Honor, we have 2 witnesses today. The first witness would be Zachary Barthel.
Okay. You raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth?
I do.
You can have a seat, and will you state and spell your last name or your full name?
Full name is Zachary Barthel, Zachary, B as in boy, Arthel.
How are you employed?
I am employed by the state of Maryland as a power plant siting assessor in the power plant research program located within the Department of Natural Resources.
Okay. Did you conduct site visits in this matter?
Yes. Yes, Your Honor.
Do you know when? What the dates were?
I can find that information if you give me a moment.
Your Honor, I do have one question.
Sure. I'm sorry.
Oh, no worries. I just do you have any corrections to your testimony, Mr. Barthel?
I do, Your Honor, if I may.
Go ahead.
In my direct testimony on page 22, let me find the line here. Starting at line 10, the applicant plans to plant a 25-foot wide landscape buffer around the entire project except for the southeast corner, where a vegetated area greater than 50 feet wide already exists on the project property. Well, that vegetated area does exist and is there, but that is an incorrect description about the southeast corner. The no buffer portion of this project is really located along the north to northeastern side. So I would correct that piece.
Did you also know at the time of, do you have any further questions?
I believe, Your Honor, he has one other correction.
Oh, go ahead.
I do. Within the PAR, actually, I'll have to find that. Hang on a second. Under the economics and jobs section, my testimony is correct on the number of jobs that would be potentially created by this project. So testimony is correct. The PAR is wrong. Testimony says 28 jobs. PAR says 52.
So it should be, what page?
Let me find that for you.
Sorry. Or what page of your testimony, I guess?
Page of the testimony is page 28. Line 22.
28 jobs, this is right, and the PAR is wrong, and that one stated
52 jobs. And as a little background there, Your Honor, not that it means that much, but we initially do a review of the ERD and we start creating these documents. We will default to the information provided by the applicant, but then when we verified it ourselves independently, we would update that. In this case, the PAR did not get updated to match the testimony, which does have the correct number.
And I believe it's actually on page 12 of the PAR. In the
Thank you.
Sure, and it says 51.
I can verify the date of the site visit if I'm given a moment. November 10th, 2025.
okay. Just the one, right?
Correct.
Okay. On page 12 of the PAR, it says the project will create around 51 jobs with an estimated 32 design, management, and construction jobs. So if we're changing it to the project will create 28 jobs, do we know what the second number is, the estimated design, management, and construction jobs?
Yeah, so the direct versus indirect is the breakdown there, and I'll get to the PAR, but that should be 6 for the design.
28 jobs with 6 design, maintenance, management, and
Right.
construction jobs. Okay.
18 would be the direct and construction related jobs. 6 would be the indirect or design related jobs. And then an induced amount, which is reflected by the model in the uptick in jobs related to those other jobs, and primarily the 18 direct jobs, and how that would translate into more work for locals.
Okay. Any further questions?
No, Your Honor, that is all.
With regards to your change to page 22 of your testimony, where the southeast corner is not the best descriptor of where there is no landscape buffer. At the time you wrote your testimony, had you seen the version of the site plan that the applicant filed on the same day that you filed your testimony?
No.
Okay, so you were not aware then that the applicant was going to install a 35-foot wide landscape buffer?
On May 29th?
Yeah. I just wondered if I should change this other portion on page 22 to 35 feet wide.
Yes. So I was aware of the 35-foot nature of the buffer, but if I'm trying to be consistently, it would be 35 across the board where it says 25,
Okay.
which was based on prior designs.
Okay. So you're gonna have to bear with me on this. Were you the sponsor of PPRP's response to bench data request 1?
The co-location bench DR.
Yes.
Yes.
Okay. Were you aware of the items heard on the Commission's administrative agenda 2 weeks ago that prompted that DR?
Yes.
Okay. And as a part of that response, PPRP said essentially a 3-mile, I guess, radius is the appropriate part to look at, correct?
Correct.
Okay. And PPRP is only aware of pre-application meetings and applications with 2 megawatts or above. Is that right?
Greater than but not equal to 2, yes.
Okay. Can you take a look at that map that I generated? Okay. You see 2 yellow lines there? Directly above the 2 yellow lines is the portion of the property for this application, is that right?
Correct.
Okay. The bottom of those yellow lines are connected to a solar that was not a part of your response to bench data request 1.
Correct.
Are you aware of which solar facility that is?
I'm aware that the name of it is Cannonball Solar. That was provided at the 2 public hearings by members of the public and is something that's verifiable by basic internet
Sure.
searches.
So staff alluded to at that administrative agenda meeting that staff might be in the future providing some sort of searchable database where developers and, I don't know, others in the industry and maybe the public can identify nearby solars. That's not available yet, but a lot of this information is available to staff or to PPRP, but not to others. But it's something that we rely on when we're trying to take a look at siting. Are you familiar with an MEA website spreadsheet, the Community Solar Project Status?
Yes, I am.
Okay. I have one that I found on the internet dated August 14th, 2025. And it indicates that Cannonball Solar project, which is very close. I thought it had it written down.
I had
Close.
approximately 1,850 feet.
It says 0.3. The closest yellow line there is 0.34 miles according to Google Earth, and the largest yellow line, which is from access road to access road, is 0.67 miles. So MEA's website spreadsheet, Community Solar Project Status, identifies that as Cannonball Solar, MEA ID utility number PE6572, located at 11533 Hessong Bridge Road, in service with a project size of kilowatt AC 2000, which is what in megawatts?
You said 2,000 kilowatts, yeah? 2 megawatts?
2 megawatts. In service in June of 2024. And I realize that this is not that solar project, Cannonball Solar, is not the farm directly next to this farm. However, it is within, 0.34 miles of this. So, is there a reason why that wouldn't have been included in your response?
The main reason would be that PPRP does not review projects that are less than or equal to 2 megawatts.
Okay, so if it was 2.01, it would have been included, but not if it's at 2.
Yes.
Okay. So as far as a visual impact, like a collective visual impact, right, of this project now in close proximity to the other project, does PPRP take that into consideration?
So I'll provide an answer, and I don't mean to be evasive on this. The short answer is, with this particular project and how it contributes to the overall visual, the view shed of this project, no. Currently, we do not, because it's not adjacent to the proposed project, and it's less than our threshold for analysis for things that we review. But if I'm getting lost in the sauce here. If you want to ask your question again, maybe I can answer it more directly.
I don't think you're lost in the sauce, but residents of this area driving down Hessong Bridge Road will now see 2 projects within a third of a mile from each other from the road. The Cannonball Solar is further back than the other one. So as far as, impact to the community, I wondered if it was something that PPRP considered, the additional.
We are interested in this very topic. This is currently under review. I forget the phrase, but since the admin hearing, which one of those 2 cases was mine, so I was representing PPRP in comments on that particular day. It's under both the Telegraph and Harkins cases are under advisement with the PSC. So PPRP is certainly, I noted at the time, and this remains true, PPRP is motivated to coordinate with staff and figure out a best path forward. You've already noted some of the important elements that may be happening as we speak, at development of a public-facing database of subscriber org numbers. These things don't catch everything. You're pointing to a project in this particular case that is visible on GIS maps, but is not fully coordinated in any sort of cumulative review, which I will also note PPRP does not perform cumulative analysis. So, but that being said, my point was that these issues are currently very specific to those 2 cases. They are under advisement by the PSC commissioners, so I would presume, without musing too much in front of you in this particular case, that there will be more to come that will give guidance on this.
I understand what you're saying about PPRP not doing a cumulative analysis. However, in the Harkins case, there were 5 solar projects, and not all of them touched each other. It wasn't, all 5 of them were not touching at one point. So there's appears to be one piece of property in between the Cannonball Solar and this property. Mm-hmm. If that third, I understand staff's position about subscriber organization number and first in, but it could be, it's feasible that if the property in between these projects decided to develop solar, that all 3 of these projects could be.
Right. So one of the issues, and forgive me, Your Honor, I would. There was Harkins and Telegraph. I believe in Harkins' case that the other 4 around Harkins in the center were adjacent parcels. In Telegraph, they were separated by a right-of-way.
In Harkins, they were all adjacent to Harkins, but not to each other.
Correct. Right. So, okay. Thank you. Clarification. The proposed methodology, which is again under advisement by the PSC commissioners, that staff has promulgated or put forward, I may not be using the right phrases here, is a first come, first serve hierarchy, and there's some elements who subscribe first and where they are in the development process would define certain things. Without musing too much again, if the person in the middle here, so one thing to note is community solar to community solar is a co-location adjacency issue which triggers requirements and restrictions such as having agrivoltaics or LMI, low to moderate income. Since Cannonball Solar in this case is not, but in your scenario, if the parcel that's in between the proposed project and Cannonball decided to develop, the density would be increased. People would see more solar. These are all true statements. It depends on the project that they would develop. Of course, if they developed it as solar, and I'm probably, I'm saying things that you know, forgive me. If they tried to do a subscriber org-based community solar project, that would have to go through an analysis that would immediately yield that, at least currently, the first come first serve would be this project 9804. How that plays out is, could you put less than 2 solar megawatt projects on surrounding properties? Possibly. And if you're asking me how do we catch them all, I don't have a good answer for that one yet.
That really is my question. How do we catch them all? You would agree with me, wouldn't you, that 7207 requires the commission to look at aesthetics, right?
Yes.
And having 2 solar projects visible from a road a third of a mile from each other would be something I should consider in this case.
That sounds reasonable and appropriate, Your Honor.
Okay. So I guess I think I was rude and asked the question and didn't remember the answer. The applicant filed a new site plan on the same day that you filed your testimony. Had you seen it prior to filing your testimony?
I'd have to look at I believe the response date on that was May 15th. So it's very possible that I saw that before it was filed by the applicant's attorneys and before I filed my testimony.
Okay. I'm gonna get your testimony in. I would suggest that you do that as well.
Okay.
On page 6 of your testimony, at lines 9 through 10, you indicate that the project is located in the Little Hunting Creek and Sandy Run watersheds. Why is that important?
Those are both tributaries of the Monocacy River, and water quality is an important and prioritized element of the state's management of natural resources. So proximity to those elements needs to be considered in siting and project development.
What is PPRP's recommendation in this case?
The recommendation of the Secretary of DNR and MDE is approval of the project.
Portions of the site are raised from the roads surrounding it. Is that correct?
Yes.
Okay. How does that affect stormwater management?
Stormwater management is could be affected by increased and decreased elevation. The important part of that feature is the local review process with delegated authority in the final concept site plan review done by the county, and that would capture any concerning elements based on topography, elevation, in terms of potential runoff and sediment erosion issues.
You said on the break that you thought it was 84 degrees in here, and it is 84 degrees in here, so I apologize, everyone. I've opened the doors. I don't know what else to do.
Thank you, Your Honor.
You win the prize. Okay, you indicated in your testimony that you accepted the glare analysis proposed by the applicant. Based on an 8-foot landscape buffer,
6
right?
foot and 8 foot.
6 foot and 8 foot, representing what? Representing what years?
Year 0 and year 2.
You have been in the hearing room listening to the testimony from the parties, is that correct?
Correct.
Did you hear the testimony that stated that the residence directly west on the other side of Hessong Bridge Road is at an elevation of about 414 or 416, whereas the panel directly across the street is at an elevation of 408?
Yes, Your Honor.
Okay.
Did we have the road measurement too? Was there an estimate of that?
411.
411. Thank you.
And medium measurement at full tilt, I'm not clear if it's the max measurement or the medium measurement at full tilt, puts the top of the panels at 8.5 feet. At the end of the day, tilted towards the residence. Do you continue to feel like it's appropriate to not update the glare analysis based on that testimony?
Do I think it's appropriate to update it? Yes.
Okay. So,
what I'll volunteer is, I can find it here, you'd already referenced it, I believe, in one of PPRP's, I think it was bench DR3, 3-3. We asked about the discrepancies, and the applicant provided a response, which I could read into the record, but it essentially says that first one was incorrect inputs. Erroneous inputs and should be disregarded. The corrected analysis confirms that no anticipated glare impacts are expected from the project. And then we asked a question about why 8 feet versus 4, all the buffer confusion. And they clarified that they used a 6-foot buffer and an 8-foot buffer. I will say that the Solar Forge modeling software, the orientation of the project, I'm looking at the map here. So this is better, if you don't mind.
nope.
It's a reasonable assumption to say that if these things are at their full extent in their western trajectory, how is this house getting zero exposure? I would probably say that PPRP could review the existing analysis. If the angles were incorrect and they were corrected, and the 6-foot buffer is mitigating a lot of glare in this case. I'm a physicist by training, and I would not say that the modeling is impossible, but these are not unreasonable questions.
Okay. Did PPRP consider the transportation effect on Hessong Bridge, which is a one lane bridge?
Yes, only in as much as typically the operations associated with construction are limited, and as this is a one-lane road over that particular bridge, as you note, they would have to coordinate with local and state highway administration. Although it's not a state highway, there's possibly the traffic plan that was mentioned by the applicant would have to be approved and reviewed. If there were significant gaps in the ability to stage out delivery of construction, as well as employees that are performing the work, that would be reviewed in that process for sure. That would have to be something that the local authorities and experts in that area would be cognizant of and comment on.
MHT identified Hessong Bridge, but said there is no adverse impact. What does that mean?
Typically, what that means is if the project as presented does not touch, potentially physically interact, there is a rubric that they use, which essentially says is if you're not changing anything that will affect this property or access to it. Now, I want to add that on this particular case, what the applicant mentioned in the review is that MHT has designated this as a historic site. But what the applicant said is certainly true in this case, that the bridge no longer exists in the form that MHT declared it to be a historical site. And that is, without clouding the issue, and MHT, their documentation in this issue is 20 years old, and they are, much like many state agencies, overwhelmed with work, and they can review the existing project on its merits, and as long as it doesn't touch or affect access to it, typically their response is, as noted in this case, which is a non-event.
Touch or affect access. Does that mean you can't get to it, or does that mean the view from it or the view of it?
Access. We see this in several MHT-related sites. So if you have a historic cemetery, we've had those outside the LOD of a project. This is a bridge that's outside the LOD of this project. As long as you can access it normally or provide an alternate, there are certain scenarios where they'll allow some entanglement or disruption of normal access, but it's very site-specific and specific to the project elements as well.
Have you had a case where MHT said no?
I've had cases where they said that the applicant needs to provide a different access.
Okay.
That is not uncommon with cemeteries.
Did MHT identify any other properties of interest or items of interest?
MHT did not specifically identify other projects of interest or areas of interest. You noted a couple that
Those are my next questions.
I found as well on the National Registry. And actually it does show up on Medusa, because Medusa pulls from different different DBs, databases. One of them is the Sandy Run farmhouse, which is on this map, maybe not on that one. It's a third of a mile away. It's this one right here. So one of the public comments, Your Honor, was there's 6 historic sites. I did not find six historic sites in this, and it doesn't show up on MHT's search. This one is a third of a mile away. It's a specific house style that is representative of farmhouse styles from the earlier part of the century. The Black Mill District that you noted is 3 miles away and is no longer, to use MHT's phrase, extant. So the buildings, which were 5 that comprise that site, the Black Mills District, no longer exist.
And Catoctin Furnace?
That one I did not get a hit on.
So whose responsibility is it to identify these properties? Because the filed testimony in this case don't address these other properties.
I would say that primarily the applicant is responsible for identifying these properties through the existing authoritative resources. And as a state employee, I would say that's MHT in the Department of Planning. If the hits don't come off that, then certainly it's up to Your Honor to review these other situations. But we default to subject matter experts, and certainly we consider them that. I don't want to muse out loud too much, but the Catoctin Furnace one, I don't have any concept of how far away that is or which registry that showed up on. But perhaps that's just an example of, we do the best we can in these situations, and if MHT is our expert, then we do well by going with their recommendations.
The requirement for the viewshed analysis was triggered by the proximity of the project to preservation areas, rural legacy areas, priority preservation areas, public parks, scenic rivers or byways, or designated heritage areas, or historic structures or sites listed on or eligible for the National Register of Historic Places or relevant county register of historic places within 1 mile of the project. Is that something that PPRP considers, that list of types of things nearby?
Only in as much as MHT cares. I don't mean to be glib about it, but if currently the standard process would be if an applicant uses MHT as a resource to determine if there are effects on historic properties, we currently don't go further than that.
Okay, well, I don't think MHT would identify public parks, would they?
No, unless they were historic parks.
Or scenic rivers or byways?
Scenic rivers, that one is we do catch that in our analysis. A lot of what you did say we do review. If they are in PPAs, if they are in this case a scenic river watershed, those are things that we do look for.
There was a public comment about the impact on Little Hunting Creek and fishing. Do you have any comments on that?
I don't. I would add on to what the applicant said. What this project does on the owner's property would not impact the Mr. Troxel, I believe, the member of the public. His comment was, I don't think it would affect his access to the river. Would it affect the quality of the river? The state's opinion on that is no. There are best management practices that have been recommended by all the agencies that would contribute to minimal, if any, impact at all. The setbacks, the control of sedimentation, these are all things that would minimize any sort of effect on the Little Hunting or Sandy run, which are going into the Monocacy.
You testify that Frederick County issued a review letter indicating that the project was consistent with the September 2019 Livable Frederick Master Plan, and provided technical suggestions, and indicate that the applicant intends to comply with those suggestions during the local permitting process. Those suggestions were not made a part of your proposed license conditions. Is that correct?
Correct.
Why not?
The variance that is 23 counties and 23 jurisdictions, PPRP tries to manage the state's concerns about a project from a high enough but as low a level as it needs to be. And the local concerns need to be directed and confirmed between the locals and the applicant. The state would not want to get in the way of that. So we don't typically reference or note those in our own RLCs.
And in making its recommendation, PPRP relied on the representations made by the applicant in its filings. Is that correct?
That is correct.
So if an applicant post CPCN issuance changes something in its site plan with the county, that may change PPRP's recommendation in the case. Is that true?
Certainly. If you have a site plan modification post CPCN and pre-construction, for instance, PPRP would like to look at that.
The Creek Relief Program, the Frederick County Creek Relief Program, is PPRP in support of the applicant or the landowner complying with that program?
Yes, I mean that one is PPRP doesn't typically need to or respond to specifics. The applicant noted that it's adding in vegetation to create a riparian buffer. These are all things that the state encourages. In a sense, we do coordinate these sorts of, at least the communication responses on these issues, because our land management program at DNR is a pass-through for communications between an applicant and the local conservation district, in this case the Monocacy Commission.
I heard your answer to my previous question about whether or not PPRP made a specific recommendation a part of its general recommendations. I have another question about that, though. With the response to your data request 3-5 about existing foliage, the applicant indicated that it intends to preserve the existing vegetation along the stream by including a 50-foot vegetative buffer within an easement as part of its agreement with the landowner, and that the applicant or its designated operations and maintenance provider will serve as the party responsible for ongoing inspection, maintenance, and replacement of any vegetation as needed. Did PPRP consider making that a part of its conditions in this case, and why or why not?
I'd have to, and I can do it right now if we have the time and the temperature tolerance. I can look at that condition. I don't know that what is stated explicitly by the applicant here is not included within the language of our condition, but I can look at that.
That's fine. Hold on a second.
Your Honor, I'm sorry, I was looking at something. What was your question about the existing?
PPRP DR 3.5, the response from the applicant, whether or not PPRP considered making that a part of its conditions specifically. 3.5.
Is that with the existing vegetation?
Mm-hmm.
I do believe 32, condition 32 does reference that some.
It does. It's close. Yeah.
Thank you, Your Honor.
I don't believe I have any further questions. Thank you very much.
Thank you.
Ms. McLemore, do you have any questions?
No, Your Honor. Thank you.
Thank you very much. Your next witness, Ms. McLemore?
Yes, I called Miss Jessica Olansky to the stand. Okowski.
Do you swear or affirm under the penalties of perjury that the testimony you're about to give will be the truth?
I do.
Can you state and spell your first name and say how you're employed?
Jessica Olkowski, JESSYCA, and I am a project engineer with GFT, who is a contractor for PPRB.
Any questions?
No, Your Honor.
Do you have any updates to your testimony based on, this was filed back in May, and the things that you talked about in your testimony, things have happened since then?
Yes, so both the documents I reference in my testimony have either been superseded or are under revision based on the hearing and other things that have been issued for a PSC case 9873.
Okay, so do you have any updates as to your testimony based on that progress?
Other than the decommissioning agreement now has been superseded by a draft agreement that was issued by the PULJ division, and but is still in draft form and would not be required by the applicant until it is issued and adopted by the PSC.
You gave a long list of decommissioning plans that you reviewed.
Yes.
Did you review the cost estimate in this case?
Very briefly.
Do you know if the cost estimate in this case is commensurate with some of the other cases that you've reviewed?
I don't believe I reviewed it to that level of detail, but I don't recall seeing any red flags upon a cursory review.
Okay, I don't have any further questions.
I have no questions, Your Honor.
Thank you for your time.
Thank you.
Any other witnesses for PPRP?
No, Your Honor, that is it.
Commission staff.
The commission staff calls Roger Austin to the stand, please.
Do you swear or affirm under penalties of perjury that the testimony you're about to give will be the truth?
I do.
You can have a seat, and will you state your first and last name and your employment for the record?
Roger Austin, ROGERAUSTIN. I'm an engineer at the Maryland Public Service Commission.
Thank you.
All right. Your Honor, I am going to have to ask Mr. Austin to adopt Mr. Spiegelman's testimony, so I will do a brief direct examination with that intent.
Go ahead.
Thank you. Good afternoon, Mr. Austin.
Good afternoon, Mrs.
Do you have in front of you a document entitled captioned in Commission Case number 9804, that's this case, and entitled Direct Testimony and Exhibit of Mikhail Spiegelman on behalf of the staff of the Public Service Commission of Maryland, and dated May 29th, 2026.
I do.
Have you reviewed this testimony?
I have.
And is it typical of the testimony that staff generally prepares for this sort of proceeding?
It is.
And do you adopt this testimony as your own testimony in this proceeding?
I do.
Thank you. Your Honor, this was marked and admitted as Staff Exhibit 1 previously.
Yes, sir.
So, and the witness is available for any questions.
Mr. Austin, did you sponsor the response to bench data request 1?
I did.
Okay. So there is a property that has a solar facility on it that's about a third of a mile from this property. And it's a community solar property in operation at 2 megawatts and has been in operation since June 13th, 2024. But that was not marked as a part of your data response. Is the reason for that because you're only responding to parcels that are adjacent to the property that was inquired about?
Yes.
How does staff define adjacent?
Staff does not define it. We used your definition.
Okay.
If I might, Your Honor, just, are we sure that that is actually a community solar project? Because if it weren't, that would be another reason it might not show up on staff's review.
The subscriber organization number is 17A21502100038744. It has a subscriber name and address number. It's indicated as a yes.
If you like, I can ask the EAP people who maintain that database about it and see what they tell me.
Staff in his explanation, I'm not going to dig through my files of paper, I'm just going to pull it up. Staff in its response indicated that
Yeah, we said there are no CSEGs on parcels that adjoin or are separated.
It may also be, given that this has been in operation for 2 years, and maybe that this was part of the pilot program, and that might make a difference. I don't know.
it's possible. I'm happy to, if you want to look into it, I'm happy to give you, this is PPRP's huge big spreadsheet of projects, and I have it highlighted, but it's really small. So I'm happy to give that to you if you want to.
Yes, I would appreciate that, Your Honor.
Yeah, I'll just. Is there another way that staff would be able to advise as a part of its testimony in a CPCN case as to nearby solar facilities?
Well, the staff engineering, we have a very narrow area of focus in these CPCN testimonies, and that is how these facilities affect the reliability and stability of the grid, and whether or not, and ensuring that any upgrades that are necessary to be made to the grid are not passed on to ratepayers. They are borne by the facility. That is our focus. So the engineering staff is not really looking at nearby facilities and that.
I'm sorry to put you on the spot.
Yeah.
I recognize what staff's focus is on these types of cases. However, one of the things that the commission has to consider are aesthetics. And staff is the only one that has this information about community solar projects.
Well, I mean, we have the information we have about community solar projects will be location. We don't, for example, have any view shed information. So, we don't do any kind of site visits, and that's really the only way to do that. We have been, we have a database that says what the community solar projects are, but it's limited to community solar. It doesn't cover other projects. So that's one limitation we've got. Another limitation, they has to do with older projects that were not necessarily put into the database the same way that new and current ones are. We're still kind of working through that. We are still, as you alluded to earlier, trying to figure out the definition of adjacent, for co-location purposes and assessing that. So a lot of that is kind of up in the air. So, if we get one of these bench data requests, which we've gotten for most of these cases, we will answer to the best of the information we have, but we don't necessarily have all the information that they're seeking.
I understand. For this case, the bench data request asked for nearby projects and define nearby as adjoining properties, i.e. those that share a property line with a property on which the subject project is proposed, which the one that we're talking about doesn't qualify. Right. On properties separated by a right-of-way, and on properties from which any portion of the subject project could be visible in year 0.
Right.
So PPRP's response drew a circle with like a 3-mile radius to say could be visible in year 0. They were not able to identify this property because it's at 2 megawatts. Staff focused on the, adjacent property line, but this additional project was 0.3 miles away. And so here we are at the date of trial, and there's no evidence in the record about this property, which should be considered as a part of, the aesthetics of the property that we're here for, right? So is there a better way that I can ask staff that question so I can get things nearby?
I was actually under the impression that the people who actually pulled the data from the database had actually looked and answered that there weren't any nearby for this project. So I was a little surprised that we've got the one there. And like I said, I need to investigate to find out why that slipped through the cracks, or why specifically it was not caught here. So, because that sort of thing, if a community solar project should show up. But essentially, it's a visual search that I think they do on the things that are mapped into the database. So, and like I said, it may be that sometimes there are some of the older ones that are not, but that's probably about the best information we've got.
Okay. I realize that this is something that we're newly focused on.
Right.
So it's an evolving issue.
We're all kind of muddling through this right now.
Yeah.
Until we get things more regularized.
It would just be nice to know this information, sooner rather than later.
Right.
Okay. All right. Thank you, Mr. Austin. I don't have any further questions.
Thank you.
Thank you, Your Honor.
Does anyone else have anything else that we need to take care of today?
Your Honor, in order to rectify the view shed and glare analysis issue that was earlier identified, would it be possible to leave the evidentiary record open and allow the applicant an opportunity to cure this issue?
Yes, I'm going to leave the record open because I don't have enough at this point. However, and I do think the applicant should start working on a view shed analysis and a glare analysis. However, I would like visual renderings.
Your Honor, I was taking some notes while we were discussing this. Would you allow me just a minute to discuss with the applicant our next route forward, and we could propose what might be suitable in this situation?
Yeah, absolutely. Do you want to go out in the hallway, or do you want me to leave, or and how long do you need?
Probably just like 2 minutes, and we can exit into the hallway.
Okay, I'm gonna use that time to get together the list of addresses that I want visual renderings from.
Thank you, Your Honor.
Thank you. There are witnesses that don't want to stay in this hot, sticky room. You can be released.
It's a joy to work in a building that doesn't work. Yeah, I don't know. Problem with aesthetics is nobody quite knows what it is. Yeah, pretty much does. So, I mean, somewhere in the database, that number and application has to be recorded. But why? Yeah, no. I mean, if they don't, absolutely. That's what I was saying just now. I mean, if it's just a solar facility and they're just doing net metering or just a commercial facility, and they're not going for the community solar trough, then we don't necessarily have a record if they're under the 2 megawatts and don't need a CPCN. Um, yeah, that might be a reasonable legislative proposal. Well, I mean, essentially, maybe anyone building a solar facility, that's not on a residential rooftop. Um, yeah. But I mean, the co-location thing. I mean, you saw what happened with Telegraph Roads and Harkins Lane 2 weeks ago, and that question is really a tough one. Commission apparently is not happy that we brought it to them, but what were we supposed to do? You know, but yeah, I mean, you know, the legislature basically set it up, so everybody has to, you know, it's either all or nothing, or you know, all or the first one, you know. If there is any kind of a loophole of any kind whatsoever, the community solar people will drive a truck through it.
This information
Yeah.
I had in my notes, so it's easier to read.
All right. Thank you, Con. I appreciate it. But I mean, you know, I mean, to be fair to the solar people, I think they just want clarity. But you know, they do have a tendency to push the limits. So. I have at least one person on staff who wants adjacent to me 1,500 feet. I suspect that is not going. That's yes. I suspect that is not going to fly, but that person will be pushing for it.
Yeah, this heat makes me sleepy.
Well, there's a reason people in hot climates take siestas.
The tiny spreadsheet that I was referencing before, I had in my notes made that a little bit bigger, so I gave one to each council, so about the Cannonball project, so you can actually read it.
Thank you, Your Honor.
So what did we come up with?
So the first part of this, we would propose to create the visual renderings from years 0 to 5 in maturity that we've seen on other bench data requests that shows it from neighboring households, and the applicant will do their best effort to get onto the properties and take those photos, and if not, they'll create an affidavit explaining exactly what they've done and why or why not they were allowed or disallowed onto adjacent properties. And then it will show if there is existing vegetation, we can show leaf on, leaf off rather than the renderings, and then explain where the viewpoints are so that it makes so we're explaining where the photos are coming from, because I think that was an issue with the 8 viewpoints on the previous analysis. It didn't have any explanation. And then and then just pictures from the surrounding property, and we're going to meet the requirements that have previously been issued for bench data requests.
Okay. If the property owners do not allow the folks on their property, and the photo renderings have to be taken from the street, it should be at the same elevation as the property. The street on this is below, in many portions is below the actual properties. So from the street wouldn't work unless it's taken like a camera on a pole. You know what I'm saying?
Yes.
Okay.
On the explanation of where the pictures are taken from, probably would be helpful if you'd map that out as well.
Yes. The second item that the applicant would propose is providing an updated landscape management plan that more accurately reflects the actual height of trees at planting, it will be updated to meet the licensing recommended conditions by PPRP, and it will explain watering, whether that is trucked in or if there is using a well on the property, and it will identify where that well is on the property.
That would be very helpful.
And then additionally to that, the applicant has submitted a landscape, I guess that this is considered a ground management plan, but that to meet the licensing condition, but the applicant has submitted also a landscape management plan to the county, and we can include that within this submission. It is currently under review, however, so it's not its final stage.
That's fine.
And then finally, the applicant would propose updating their glare analysis to show both full tilt, which was the 9.5, and also the median tilt, which is around 8 feet. In that, along with the updated glare analysis, we can explain the differences between all three glare analyses in detail to explain how we're getting to this final result. And we would also propose sending that to PPRP for review prior to submitting to Your Honor.
I was going to request that of PPRP. Is PPRP able to take a look at the glare analysis?
Yes, Your Honor.
Unfortunately, we didn't have a court reporter today, so I'm going to have to take a look at the recording of this hearing just to supplement my notes with regards to what questions weren't answered.
Mm-hmm.
I might suggest that the applicant do that as well in case there are other questions that I may have. All of those questions are based on my review and my drafting of the preliminary portion of the proposed order.
Mm-hmm.
So I need answers to all of the questions that I've asked today. And I may not have enough time to review this hearing before the end of the week. So if you want it faster, it'd be better for you to take a look at the YouTube
Yes,
feed
Your
from
Honor.
this.
And just to clarify, would you want us to write down in length all the answers to those questions, or just the ones that we might have missed and not provided?
The record's open. I'll eventually get to it and get
Yes.
to asking you. But if I know that you all are in a hurry to get this done.
Absolutely, Your Honor.
So if you all can get to it before I can, it would make things go much faster.
Yes, Your Honor. I was just trying to clarify which we are just looking for questions that we might have not been able to answer or missed on the stand. You don't want a full list of all questions and answers. Okay.
No,
Just
not at all.
I'm just.
It's merely a suggestion. It's not a request.
Yeah. No.
I will
we're
eventually
happy
get
to.
I will eventually ask all the questions I need to ask, but I know that time is of the essence.
Yeah, we're happy to do that. Speaking of timing, however, because the visual renderings take a while to contact the neighbors and to get their permission and to actually physically go to the property, we would ask that we be given a month and a half to complete this request. The applicant's thought process behind that was that they would give 2 weeks to check in both weeks with the surrounding property owners, and then it would take at least 3 days to go out, take those photos with the property owner's permission, and then it would take an additional 2 to 3 weeks to create the renderings. And while the applicant hopes to complete this prior to a month and a half, just to give a realistic, conservative expectation, that's what the applicant would request, Your Honor.
I am right now attempting to see if the applicant, I'm assuming, since we are where we are, that the applicant has waived the 365-day, or that it will.
We are willing to waive that. I think
Okay.
we're past the.
I'm not going to give the applicant a deadline, but the sooner you do it, the sooner you get a proposed order, right? So, yeah.
Understood.
Yeah, I'm not going to give a deadline for this. I'll just react to it when I get it. But please email a copy directly to me and to the party so I don't have to continuously monitor the docket.
Yes, Your Honor, will do. And Your Honor, are you going to produce this bench data request, or are my notes sufficient to?
Your notes are sufficient. I've taken notes based on what you've said.
Mm-hmm.
It's also being recorded.
Yes.
But as I'm continuing to draft my proposed order, as I run into questions, if I don't have answers yet, or I don't think the record is sufficient, I'll just go ahead and issue a bench data request.
Thank you, Your Honor.
I don't have any further bench data requests for PPRP or for staff.
Thank you, Your Honor.
Right, anyone else have any other things that we need to take care of today?
No, Your Honor.
Again, I apologize for this room. It's now 83.8, so it's gone down a little bit. I hope you feel nice and cool. I will get to work on this. Everyone else can get to work on this, and thank you so much for your time today. I appreciate it.
Moment I feel
Thank you,
a
Your
little
Honor.
bit of moving air, so.
We can go off the record.